would finish off with our legal drafting course. And I hope this course is of some help to you. And when you start your own drafting, whether be it in your internships or otherwise, it provides you some sort of assistance. So in the last class, what we discussed was compromise of suits. So I told you in criminal. One second, I think there is a glitch. Let me just rejoin the meeting. So I think there was some sort of glitch. Let me just reshare the file with you. So as I was discussing in the last class, that in civil cases we have compromise which we register when we want to end the suit through compromise. However, when we were talking about criminal offences, so I told you that similar procedure is not there in your criminal proceedings. So instead we have compounding of offences. So what do you understand by compoundable offences? So compoundable offences are basically those offences which can be compounded or which can be adjusted by the parties, or the parties can resolve those offences outside the court. So basically compounding is that. So when we talked about the you know criminal procedure code, section 320 of the criminal procedure code dealt with compounding of offences, which means that if there is an offence which needs to be compounded, or wherein the parties have adjusted and they have agreed, so they can do out of the court settlement. So if you talk about in your course also, which was provided to me, I think there was only 320 CRPC which was written, but you can, since now BNSS is there, so it corresponds to section 359 of the BNSS. So again, it is a form of compromise, and but this is not allowed in all the offences which are mentioned in the section 359 BNSS, only those offences can be compounded. Now again, why is this there? Because it believes that there should be restorative justice, not punitive. Punitive means in small offences, rather than making our objective to punish the offender, we should have an objective to restore the victim to his original position, or to make good to him the loss which he has suffered. Now coming to legal basis of section 320 CRPC or 359 BNSS. So basically it talks about that which offences are compoundable, it gives a list. And who can compound it, it tells us that procedure. And it also tells us either the offence can be compounded on our own, or we have to file it in the court, or we have to take the permission of the court. The entire procedure is being laid down in section 320 CRPC. Now coming to, it has basically two categories of offences. First, which can be compounded without permission of the court. So what you can do is, if there is a minor offence like your section 323 IPC, voluntarily causing hurt, 334 hurt on provocation, wrongful restraint, intentional insult, such small offences wherein punishment is 1 2 years, like minor offences. And here what the parties can do is they can directly talk with each other, negotiate, and they can compound the offence without the permission of the court. Once it is, the negotiations are done, then they can file in the court that we have negotiated and we want the charges to be compounded. Now coming to the next part, compounding with permission of the court. Now these are not serious offences but middle, like not even minor, not serious. They come in the middle. So a bit more serious form of minor offences. Wherein you can compound them, but before compounding or before negotiating with the other party, you have to take the permission of the court. So you can see the offences like assault on a woman with outraging the modesty, criminal intimidation, and even very interestingly, or 498A, domestic violence, so voluntarily causing previous hurt. So the list is provided in your BNS or IPC, whatever you are referring to. Now coming to who can compound it. So again, firstly, if I am suffering, if I have, someone has hurt me or caused me hurt, so I as a person who is the victim can compound the offences, or the woman who has been assaulted in a section under section 354 or 498A, or what can be done is, basically the victim can compound the offences. No one else can compound it on his behalf. So who has been subject to hurt, assault, or violence, that person can compound the offence, and depends if it is a minor offence without the permission of the court, and if it is a bit serious offence, then with the permission of the court. Now, what happens after the offence is compounded? The accused gets acquitted, and it has the same effect as the acquittal after trial, and proceedings against that accused, they come to an end. Now again, restrictions. So as I told you, only those offences which are listed under section 320 of the CRPC, which is 359 BNSS. So it has a list. So when you open it in your bare acts, on your bare acts, you'll find a list. So only those sections would be compounded which are explicitly mentioned in the sections of BNSS or CRPC, whatever you are referring to. Now, now you might be thinking that how will the parties compromise in a non-compoundable offence? So I was telling you the other day, if it is a very serious offence, for example, rape. So even if the victim decides, once the FIR is filed, and even if it is a false FIR, she was the girlfriend of that man, and later relationship turned sour, she filed a false FIR, and once it is registered, you cannot say that, oh, it was falsely registered, because if you say it is falsely registered, then a criminal proceeding can be initiated against the person who has falsely fabricated a case against the accused. So that is why that cannot be done. Then secondly, what can happen is, you can go to the court CRPC for quashing of that FIR, which I taught you in the other class. So you can approach the court under section 482 of the CRPC. So this is the only way in which non-compoundable offences can be, inherently dealt with or compromised. Otherwise, there is no other way. As you can see, you had observed that there was a compromise which could be registered under the civil suits. Now coming to the judicial view on this. So Supreme Court has time and again held that even though non-compoundable offences cannot be quashed under Section 322 of the CRPC, however, you can approach the High Court or this, you can, go to directly to the High Court and quash the FIR only. So if you are quashing the FIR itself, FIR is the basis of the case against you, then obviously automatically the case would also get quashed. Now, how is this application drafted? So basically, first, since it is the compounding of offences, so generally we file it in the same court in which the case is ongoing. So in the Court of London, Chief Judicial Magistrate, Metropolitan Magistrate, Judicial Magistrate, any court wherein the case has the main case which is there, which you want to compound, is going on. Criminal case number dash dash in the matter of state through this complainant versus accused. Application under section 320 of the CRPC 1973 for compounding of offence most respectfully showeth that the present case arises out of FIR number dash dated dash registered. So first you will tell that what is the nature of the case, and it is a compoundable case. You will also mention if it is compoundable with the permission or without the permission, and that you have decided to amicably resolve it, and therefore the present case shall be compounded. This would be the prayer. That during the pendency of the proceedings, the parties have amicably resolved their differences. The complainant and the accused have entered into a lawful compromise on dash, copies of which are annexed herewith. So what is the similarity with the compromise we filed in a civil suit? That there also you had to file a lawful compromise deed and a lawful copy of that, and as an annexure. Here also whatever the terms of compromise are between the parties, you have to file that. Why do you have to file that? So that you can prove that there was no coercion, no mistake of fault, and both the parties with the free consent have decided to, compound it. That the complainant dash victim, namely dash, has voluntarily agreed to compound the offence without any coercion, inducement, or undue influence, as a no objection if the accused is acquitted of the charges. That the offence under section dash, so you will mention that whatever the charge is there on the accused, that falls under the compoundable decree under section 320 of the CRPC. That in view of the settlement and provisions of section 320 CRPC, it is humbly prayed that this honorable court may be pleased to allow the parties to compound the offence, that such compounding will advance the ends of justice and bring peace and harmony between the parties. Prayer. It is therefore most respectfully prayed that this honorable court may kindly A. Permit the complainant and the accused to compound the offence under section dash IPC in terms of section 320 CRPC. So why we are writing IPC also? Because here we would be mentioning the charges which have been drafted against the accused in the FIR. And why do we write these charges? So that the court can, check if these are the charges which can be compounded or not. So it is very important for the court to check if the offence falls under section 320 or not. Pass such other order and further orders as this honorable court may deem fit and proper in the facts and circumstances of the case, place, date, filed by counsel of the applicant, and here you can also make the applicant sign. So mostly the applicant here is who is the applicant here? Here either if the compromise has been filed by both the parties. So both the parties will sign, and also the public prosecutor will be signed. If this is the first application wherein the accused is taking permission from the court compromise, then both of them will sign. So it depends who is filing this application. So also if they have agreed and only accused is filing it, but see, I think here the accused is only filing it because verification was also made by the accused. So that is immaterial. Either both the parties can sign it or even accused can sign it, because obviously accused is the one who is being benefited from the compounding. The charges against him are being quashed. So he would be the person who would be signing the application. However, the compromise deed which is there, it shall be signed by both the parties. Now coming to the next application which we would be doing is arbitration. So what do you understand by arbitration? So arbitration is basically out of the court settlement which we do, and herein it is similar to the judicial proceeding since there is an adjudicator whom we call an arbitrator, but this is done in a lesser formal way, and in a atmosphere or environment wherein the parties can also negotiate with each other. So it is in the form of an out of the court settlement. Why was arbitration brought into existence? Because India signed the Universal Model Law 1985, wherein we talked about providing fair, efficient, and speedy dispute resolution. So, if we are overburdening courts with arbitration, negotiation, mediation, and so there would be pendency of cases. That is why, to reduce the pendency, we have made these settlements out of the court. Now coming to the sections which are important, first is section 7. So basically, when can you approach the court to send your matter to the arbitration? Not everyone can go to the arbitration. Arbitration is based on an arbitration agreement. So as you remember when we were drafting lease deed and such deeds, so we were mentioning that any dispute shall be referred to the arbitrator, such things, sale deed, agreement to sell. So same here is the procedure. If there exists an arbitration agreement which is in writing, or it can be through a clause in the contract, or it can be in the any deed that they had signed, or they had separately made an agreement that if there would be any dispute which would arise between us in the future, so we would be going to the arbitrator. So they should have a clear cut expression, that they should have expressed their intention in some sort of written form somewhere that they want to submit their dispute for arbitration. So what is the essentials of a valid arbitration agreement? First is very simple. There should be an intention of the parties to submit their dispute to arbitration. It should be in writing. And again, the relationship, for example, the deed or the contract or the relationship which we are disputing, that should be a legal relationship. Again, any agreement, contract for illegal objects is not, considered arbitrable. Now, arbitration must be chosen as a method for final resolution, which means that the parties have to choose that they want themselves to submit to the arbitration. This is very important. You cannot force a party. They have to write this clearly that their final method resolution should be arbitration. So now section 8. Okay, fine. Once you establish that there is a valid arbitration agreement, then you will go to the court and you will ask the court to refer the matter to the arbitration. So, for example, if I have agreed with the party and I have bought a piece of land, and we agreed that if there would be any dispute in the future, we would go to the court. But however, once we decide that once the dispute arises, instead of filing for arbitration, you go and what you do is you file a dispute in the party or in the court. So the respondent, what they would do is they would refer to the court, they will file the arbitration agreement, and they'll say that court does not have any jurisdiction here because we had an arbitration agreement, and then the judge will refer the matter to the arbitration. So it is not cases, I can not, revert that part. I have to go to the arbitrator. So section 8 talks about the power of judges, that when a party files a civil suit wherein they had already agreed that they will go to the arbitration, then they can refer such parties to arbitration if there is a valid arbitration agreement between them. And the application is made before the submission of the first statement on the substance of dispute. Okay. Now coming to the next part, which is section 11, appointment of the arbitrators. See, either there can be a sole arbitrator or there can be three. So mostly there have the number of arbitrators are odd, so that there are no chances of disputes occurring, or no chances that there should be equality in votes or something. So we try to have odd number of arbitrators. So basically, either the parties themselves decide for the arbitrators mutually. If they are not agreeing, or if they do not have an agreement, they can either approach the High Court, Supreme Court, or District Court to appoint one. So the court's role is administrative, which means that they are just acting as an administration wherein they are appointing the arbitrator. Now coming to section 21, which talks about the commencement of arbitration proceedings. So arbitration commences whenever the other party receives the request for referring to the arbitration from the claimant. So if I have to apply for arbitration, I will also send the notice to the other party for arbitration. And as soon as that party is receiving the notice, my dispute would be considered starting. My arbitration proceedings will be considered to have commenced. Now again, certain orders, if you are applying to the court for referring to arbitration, or if your court is not granting you such interim measures, you can also appeal them to the higher court. Now coming to the arbitration proceeding, how do you uh, file an arbitration petition? In the court of district judge at this place, arbitration petition number dash of 2025, in the matter of whatever petitioner versus respondent, petition under section 11(6) of the Arbitration and Conciliation Act 1996 for seeking an appointment of an arbitrator. So to the honorable district judge at this, or you can directly write most respectfully show it, that on dash date the petitioner and respondent entered into a contract for whatever the contract was. A copy of the said agreement is annexed herewith and marked as Annexure P1. That clause number, whatever is the arbitration clause, you will refer the number here of the agreement, provides that all the disputes and differences arising between the parties hereto in connection with this agreement shall be referred to arbitration in accordance with the provisions of Arbitration and Conciliation Act 1996. The arbitration shall be conducted by a sole arbitrator appointed mutually by both the parties. The seat of arbitration shall be whatever the places. That certain disputes have arisen between the parties regarding whatever your dispute are, be it non-payment of dues or specific performance, breach of any term of the agreement. The petitioner has repeatedly requested the respondent to resolve the dispute amicably but in vain. That the petitioner issued a notice of arbitration. So you have to then write that I also ask them to directly approach the court through the arbitration proceeding, but the party did not pay it. So you'll write that also. Dated dash to the respondent in the section 21, calling upon the respondent to concur in the appointment of arbitrator. A copy of notice is annexed as Annexure P2. However, the respondent has failed and neglected to appoint or in the failure to appoint an arbitrator after due notice. This honorable court has jurisdiction to entertain this petition as the seat or place of arbitration is situated within its territorial jurisdiction and the contract was executed within the jurisdiction of this court. This petition is being filed on the following grounds: that a valid and binding arbitration agreement exists between the parties. First is this is the most important requirement. Second, the respondent has failed to act as required under arbitration clause. That under section 11.6, this honorable court is empowered to appoint an arbitrator where the parties fail to do so by mutual consent. That the dispute is arbitrable and falls within the scope of the arbitration clause. That the petitioner respectfully prays that this honorable court may be pleased to first appoint a sole arbitrator to adjudicate. What is adjudicate? Means to settle the disputes. To see, even the judges adjudicate, but sole arbitrators, they adjudicate outside the court. They settle the dispute outside the court. Second, direct the respondent to participate in the arbitral proceedings. Third, pass such order or further orders as this honorable court may deem fit and proper in the interest of justice. Any coercive steps. So if you are filing for arbitration, you cannot file for injunction, but you can ask the court that while the arbitration is going on, can you put a stay on the respondent from taking any coercive action or filing any sort of case against me or alienating the property or selling it to someone else. So this you can put in as a subsidiary or interim relief in your arbitration proceeding. Then is the verification, then the sign through advocate. Is arbitration clear? Now coming to the last topic is writs. What do you understand by writs? Anyone? Writs is something which everyone might have heard of. So basically, you know what fundamental rights are, right? So,
Writs are filed when there is a violation of fundamental rights.
yes, right. So basically, writs are one of the constitutional remedies which lie in your two articles. First is Article 32 and one is Article 226. So Article 32 is again part of your fundamental rights. So it is the fundamental right of a citizen of India to approach the Supreme Court when there is a violation of their fundamental rights. And Section 226 is a similar power on the High Court, but here you can go to the High Court for enforcement of fundamental rights as well as any other legal right. See, fundamental rights are those which are mentioned from your 2 to 32, whatever the rights that are there. So those are, 12 to 32. So all those rights which are there: right to equality, right to freedom of speech, expression, right to religion, right to education, right to life and liberty. Numerous rights you have. So only for those fundamental rights, if you are approaching, then you can either go to the Supreme Court or the High Court. But then there are other rights like right to vote, okay, right to property, which are not fundamental rights. They are either legal rights or other constitutional rights. So for that, you can only approach the High Court under Section 226 of the Indian Constitution. Now coming to nature of writ jurisdiction. So as I told you, Article 32 is itself a fundamental right and it lies under Part 3 of the Constitution. So it is basically a right wherein the individuals can approach the Supreme Court in case of violation of their fundamental rights. However, Article 226 can be invoked when there is a fundamental right violation plus any other legal right is being infringed. So now what are the types of writs? There are 5 types of writs. First is habeas corpus, to have the body. So this means that whenever some person has been unlawfully detained, so he can file a writ either in the High Court or the Supreme Court against public authorities as well as private individuals who are responsible for unlawfully detaining that person. Second is mandamus, I command to come. So now this is basically filed against any public official, public body, governmental body, or any body which is exercising public functions wherein they are not doing their duties properly. Either they're not doing it properly or they're not, completely ignoring it. They're completely ignoring their duties. So the court commands that particular public authority to perform their public or statutory duty. Then prohibition. So it is again now it is filed against judicial or quasi-judicial bodies. Quasi-judicial bodies are, although they have an arbitration function, for example, labor court and such courts, quasi-judicial. So basically, when or any tribunals, NGT, National Green Tribunal, then you have motor vehicle tribunals, XYZ. There are a lot of tribunals. So basically, in this, the higher court prevents the lower court or tribunal from exceeding their jurisdiction. So if they're acting without any jurisdiction or exceeding their jurisdiction, so they can under writ of prohibition be prevented by the higher court to do so. Then certiorari, it means it is again filed against judicial or quasi-judicial bodies, wherein the higher court can quash an order of those lower courts or tribunal wherein they have acted without jurisdiction or in excess. So see what is the difference here? This is a preventive step. Here the court is preventing them. Here they have already acted. So it is kind of a, here restorative step. So they are restoring the order wherein the court had acted without any jurisdiction. So this is the difference. Now coming to quo warranto is by what authority? So again, this is filed against public office holders. So it is filed to challenge any form of, if someone is holding any office without any authority, to challenge that. So it is quo warranto. Now coming to the next part, the draft. Now coming to habeas corpus. So I have drafted a writ of habeas corpus to see how it is drafted. So first let us understand in detail what habeas corpus is. So habeas corpus means to have the body. So it is again a prerogative writ wherein an individual's liberty, personal liberty is at stake. He has been unlawfully detained by any private or public body. So in this case, once a writ is filed, the court commands the detaining authority to produce the detained person before the court and justify that why they have detained that person. Now again, it is issued when a person is unlawfully detained by state or private person. Again, if the court finds out, or when the person is produced, or when the authority gives a reason and court comes to the conclusion that such detention was illegal and proper steps have not been taken, due care and process of law has not been observed, so they can also release detention of that person. Again, when this petition is not maintainable, when detention is lawful again under the preventive detention laws. So your Article 22, you might have studied Constitution, talks about preventive detention and all sorts of detentions. If they are legally detained under some law, then habeas corpus cannot be entertained. But if the illegal detention is prima facie seen on the face of it, then the court will entertain it, look into the merits, and if they find out that it is illegally detention has occurred, then they can order the release of that person. Now coming to many cases, so you have a lot of cases wherein time and again, especially Rudal Shah versus State of Bihar, this was again a writ petition. So time and again, court has released people who were unlawfully detained, and when they were found to have been detained for a large number of time, like for many years, like in Rudal Shah, so the court court has even awarded them compensation, monetary compensation for their illegal detention. Now coming to how do you file the writ. So firstly the court's name, it can be the High Court or in the Honorable Supreme Court of India. Writ petition, criminal, if it is a civil case you write civil, criminal, so criminal number dash of 2025 in the matter of AB, petitioner's name, son of age, resident of petitioner versus state of whatever state is through its chief secretary, government of whatever Uttarakhand, Delhi, or even if it is anything, any state and city, Delhi. So anything, union territory, whatever. So here you will write that. Plus superintendent of police wherever he has been detained. So against that SP, you will write the name of the district. Writ petition under Article 32 of the Constitution seeking issuance of writ of habeas corpus. To the honorable, see, as I told you in High Court and Supreme Court, you try to give them utmost respect. So you also annex such phrases like to the Honorable Chief Justice of India and his companion Chief Justices of the Honorable Supreme Court of India, the humble petition of the petitioner above named most respectfully showeth that the petitioner's brother Mr. C.D., aged dash years, was taken into custody by local police of whatever the name of the police station is on dash without any warrant or justification. That since his detention, his family members have made several inquiries but have not been informed about the reasons or places of detention. That no FIR had been registered or nor has the detainee been produced before any magistrate within 24 hours as mandated under Article 22 subclause 2 and section 57 of CRPC. That all attempts to trace the whereabouts of the detainee have failed and the authorities have provided no lawful grounds for such detention. That the present writ petition is filed on the following grounds. A. Because the continued detention of Mr. C.D. is in gross violation of Article 21, Right to Life and Liberty, and Article 22 talks about all forms of detentions and legal detentions and how, in what scenarios they can be illegal of the Constitution of India. Because the detaining authority has failed to comply with the mandatory procedural safeguards prescribed under law. Because the you might have heard of this case, D.K. Basu versus State of Bengal. So in that case also, court had laid down a lot of procedural guidelines of arrest and how the detainees should be treated. So they are writing that all the procedural safeguards which have been prescribed under law, none of them have been complied with by the authority, arresting authority. Because detention is arbitrary, illegal, and devoid of any judicial section, because such unlawful detention constitutes direct infringement of fundamental right to personal liberty. This honorable court has the jurisdiction under Article 32 of the Constitution of India to entertain this petition as the same is filed for the enforcement of fundamental rights. So you will write how the court has the jurisdiction. So you will directly tell them under 32 you have the jurisdiction because I want my right to life and personal liberty to be enforced. Now again it is very interesting that in habeas corpus, see, since the person has been illegally detained, so he himself cannot file a petition. So any next of friend or any legal representative on his behalf can file a writ petition on his behalf to release him from the illegal detention. In the view of the above, the petitioner respectfully prays that this honorable court may be pleased first to issue a writ of habeas corpus directing the respondents to produce Mr. C.D. before this honorable court and to set him at liberty forthwith. Second, declare the detention of the said person as illegal and unconstitutional. Third, direct the respondents to pay appropriate compensation to the petitioner and detainee for illegal detention. Who is the petitioner? Petitioner is the brother of the detainee. Detainee is the person who has been detained. Pass such other order and further orders as the honorable court may deem fit and proper in the interest of proper in facts and circumstance of the case. Pending final hearing of this petition, it is prayed that this honorable court may direct the respondents to disclose the whereabouts and health condition of the detainee. So fifth is an interim relief, because since you do not know where they have detained the person, neither do you know that if he is alive, if he is in safe health or not. So you are asking them to disclose his whereabouts and health condition. Then the petitioner declares that he has not filed any other petition seeking similar reliefs before this court or any other court. Then you will have verification. Then it is very interesting that here the verification is filed through petitioner, and then the person who would be signing it would be an advocate on record, which is not the case for High Court, but you might be knowing that any petition in the Supreme Court can be filed only through the advocate on record. So now it is very interesting that initially there was this case ADM Jabalpur versus Shrikant Shukla, wherein the court had, time and again failed to grant writ of habeas corpus. But with time, now the latest Putta Swami judgment which has come, court has, felt the need that whenever they feel that there is any sort of illegal detention, then in 90% of the cases, court grants this writ and they ask for release of the person who has been illegally detained. Now we are done with the drafts. So if anyone wants to ask any doubts, you may ask. Or if you want to show any draft, get it checked. And also whatever the drafts which were sent to me, I checked those and they are pretty decent drafts. But next time, mostly the Aparna has sent a lot of drafts, so they are mostly perfect. But when you are drafting it, try to start your sentence with that and also be concise with your material facts. So this was the only thing that I found lacking. And also, I can, share my email ID here. So if you want to, if you have drafted anything, you can send a mail to me so that I can check it and reply to you. If anyone wants to show the drafts right now, so you can present it. Anyone, you can raise your hand. Okay, then I hope this session will serve some help to you. And also you can contact me anywhere if you need any other help or you have any doubts. You can contact me on Instagram or anywhere, so I can help you if you have any doubts. So thank you everyone. It was a very nice session with you all. Thank you so much.
Thank you so
Thank you,
much,
Nyaya.
ma'am.
Thank you so much, ma'am.
Thank you. Thank you, ma'am.